Okay, so we'll go ahead and get started. My name is Matt Goodwin. I am a member of Legal's Matrimonial and Family Law Committee, and I, along with Andy Isaacson and Jess Levy, helped to put this together tonight for everyone, but really all of the credit goes to our two presenters, who I'm going to introduce here shortly. Just a quick reminder that if you are seeking CLE credit, the sign-up sheet is out on the table in front where you came in, so make sure to sign in if you do want CLE credit for attending tonight. And thank you, of course, to Seyfarth and Shaw for generously offering this space to us tonight and hosting us. Yeah, great view. So we are lucky to have with us tonight two very experienced immigration and family law practitioners to help take us through this CLE, which covers the myriad of ways in which, but not all of the ways in which matrimonial and immigration law can overlap, and things to be on the lookout for if you are a matrimonial attorney dealing with clients who may not be U.S. citizens, or who have immigration issues that they bring to your attention, or whose spouses are not U.S. citizens. One of our presenters tonight is Geoff Kagan-Trenchard, and Geoff is a fairly new attorney, but he has been working in the area of family law during before he was admitted to the bar and during law school, where during his time as a student at Hofstra, he represented children in abuse and neglect cases, as well as those seeking special immigrant juvenile status. He is the recipient of awards from both the Equal Justice Works and Public Justice Foundation. He was awarded a postgraduate fellowship to serve indigent LGBT asylum seekers with immigration equality, and helps train students in the Hofstra Asylum Clinic. He regularly works with the New York Sanctuary Coalition and organizes their legal clinic. Claire R. Thomas, our other presenter, is the director of the Asylum Clinic and adjunct professor of law at New York Law School. Claire is an attorney and interested in migration, statelessness, human rights, and empowerment for women and girls facing poverty and gender-based violence. She is the director and supervising attorney of the Asylum Clinic at New York Law School, where she is also an adjunct professor of law. She created and designed the year-long Asylum Clinic and works with upper-level students on cases, know your rights presentations, and immigration screenings. She also teaches an introductory immigration law course and provides assistance for naturalization applicants through bi-monthly immigration clinics with CUNY Citizenship Now, and volunteers assisting refugee mothers and children with the CARA Pro Bono project in Dilley, Texas. So with that, I will go ahead and let them take over and say thank you again.
Welcome. Thank you.
How's everyone doing? Good?
Good.
Thank you so much for coming out on a Monday. I appreciate it. So today we're going to cover what is arguably the most complicated area of law before the Trump administration, and is definitely a complicated area of law post-Trump administration, in like an hour and change. The plan is to just give a real broad overview of sort of the basic mechanics of the immigration system, common routes for relief and ways that people can adjust to legal permanent resident status and eventually become citizens, and then also sort of kind of drill down a bit on specific areas of practice that have come up, it sounds like, in family law matrimonial practice, and some ways to respond to those questions and ways to get you at least somewhat familiar with some of the vernacular.
And we're here for you. So if you have questions about particular areas, issues, please feel free. Raise your hand, shout it out as we go through. We'd like to, of course, address your questions. Yes.
I think it's a recording mic, but it's not an amplifying mic. Sorry.
Okay.
We have an entire free row in the front here.
Yeah.
If
We'll try to yell, and please feel free to come forward. I don't think there's a mic to amplify, unfortunately.
Yeah. Cool. Okay.
Okay.
Sound good? We're good? Okay. All right. Okay. So yeah, the agenda is to go through each of these in rough 30-minute chunks, and then we'll take questions as we go through. All right, so this is the 20,000-foot view of immigration law. So all of the pieces will be very, very small, and you will only get rough outlines of the terrain, but hopefully it will still be a little bit informative. Okay, so the first idea that I wanted to cover was, so if you wanted to split immigration, the two immigration areas into two sort of large food groups, you have the Executive Office of Immigration Review. That's the actual court where deportation proceedings are held. It's an Article 1 court, so I'll get into more of some of what that means as well later. But then the other aspect is USCIS, which is United States Citizenship and Immigration Services. They're the office where forms are processed. So when people just mail in all of the forms to adjust status, or to apply for relief under the Violence Against Women Act, or apply for asylum if they're not already in, they're technically called removal proceedings, but I find that to be a kind of Orwellian euphemism. They're in deportation proceedings. And yeah, a way to think about it is like one is an Article 1 court where all of procedural rules are very fast and loose and people's lives are ruined. And USCIS is like the DMV, where there's kind of weaponized bureaucratic forms that can ruin people's lives if one check mark is out of line. I should have included them in the slides, but if you just go to the USCIS website and just peruse the PDFs that they have to download, it's absurd to expect people to fill these things out pro se. They're incredibly complicated. They're visually very confusing. And sometimes the PDFs are actually corrupted. They put in a new PDF for the I-589, which is the sort of beginning tool for people to apply for political and other forms of asylum. And the PDF did not work. You were not able to actually type into the form itself. And it was up there for a good while. I think they've changed it, but I know several attorneys that just had to literally hack the PDF in order to make it something that they could work with.
And so for those of you who have been practicing a little while, you might have remembered something called the INS, right? So this all changed with 2002 with the Homeland Security Act. So the INS no longer exists, even though people still refer to immigration as the INS, right? That's gone. Instead, we have different agencies, and Jeff's going to show you some charts actually about, yeah. Right, I know, nice segue here. Jeff's going to show you some charts about where these agencies all go. But just so that you know, INS all gone, even though some adjudicators in family court for sure, even I've done fair hearings, other areas, people still refer to it. But just so that you know, since 2002, we've had these different agencies. EOIR, what I teach my students, I like to think of the sad donkey from Winnie the Pooh, right? EOIR, right? And that's actually an acronym. People in other areas of the country, not so much New York, will call the immigration court EOIR, right? Here people say EOIR, so just be warned if you're going to say EOIR, right? People might look at you a little strange, but it's a good way to remember it, I think, because of, sadly, the problems with our immigration system. And that, does anyone want to take a guess at how many cases are pending before poor, sad EOIR right now?
Just a ballpark. It's more than 10.
Less than 2 million. Can I have less than 2 million? 500,000. Can I have more than 500,000? 1.5. Less than a million. I'll give you a hint. 700,000, about 750,000 as of, what are we in September? As of August. Syracuse University runs the Transactional Records Account Clearinghouse, TRAC, T-R-A-C. It's a great place to look for numbers, if you're into numbers, about immigration. And they'll show you how many cases are pending, right? More than 500,000 cases are pending before poor, sad EOIR across the country. There are about 32 immigration courts throughout the country, and New York is usually the busiest. It's usually tied with Miami for being the busiest court, but in New York alone, you have tens of thousands of cases pending in New York alone. I think it's 50,000 in New York alone, but that sounds low to me. A lot, right? You have a very slow system that is extremely backlogged.
And speaking of slow systems, the shorthand often said with USIS is that if you say it fast enough, it sounds like useless, which is a fair thing. Dealing with the paperwork with USCIS can be trying, to say the least, and very Dunder Mifflin-like if you're a fan of The Office. They're in the habit of returning or requesting further evidence, oftentimes as what seems to be based on a vindictive quality that they have. Oftentimes they'll ask for requests for evidence for things that you've already submitted. There are some theories that this is because that way they can forestall actually granting anyone any immigration benefit, but they haven't actually created an appeal for you to do anything about it. So.
And one last point is the idea that we're still kind of in the Stone Ages here. We operate with fax machines, right? The fax machine is still widely used in immigration proceedings. E-filing, they said there would be e-filing. It doesn't work. You can't e-file. You have to mail or hand deliver, quite frankly, if you're at all close to the court. But everything, any sort of newfangled ways for service that are in state or the actual federal court, that has not caught on yet with the immigration court system.
Right. So, right, like night court, but not nearly as charming.
Yeah.
Right. All right. So this is the org chart that I tried to make as interesting as I possibly could, and just picture.
Your pointer person.
Yeah. Oh yeah, like that. So, all right. So the Department of Justice oversees the Executive Office of Immigration Review. Right. You see how it all sort of like flows through. And that's headed up, and policies are in many ways controlled by your friend and mine, Jeff Sessions, who is pictured here smiling enthusiastically right before he made the DACA announcement. I also point this out because there's been several explicitly political gestures by the Executive Office of Immigration Review in the Department of Justice. I want to say about 2 months ago, there's a clinic in the Northwest. Is it the East Bay Immigration Clinic, or it might be the Seattle? I'm Northwestern Immigrants' Rights Project. They provide assistance to pro se litigants who are stuck in the immigration system. They received a cease and desist letter from EOIR, which was taken to federal court and quashed, but it lets you know really exactly who's running the show.
So, immigration court, right? So your case is in immigration court. If you're not successful in immigration court, you can appeal to right here, Board of Immigration Appeals, or the BIA. That's our appellate authority in immigration lands. If you're not successful there, then you'd appeal to the circuit court in whatever jurisdiction you are in. And also your opposing counsel, which would be ICE, which Geoff is going to talk about in a minute, would also be able to appeal the immigration judge's decision the same way to the Board of Immigration Appeals.
All right. Here's the Department of Homeland Security organization chart, which came out a little blurrier.
Yeah, but these are the main ones.
Yeah. So yeah, you have U.S. Customs and Border Protection there at the bottom, along with Immigration, or U.S. Citizenship and Immigration Services. So they operate essentially sort of at parity on the org chart, along with Immigrations and Customs Enforcement, or ICE.
ICE, right? You also have the Secret Service, TSA, right? Those annoying people at the airport that go through all your stuff. FEMA, we all know how well they work. The Coast Guard, all those are part of the Department of Homeland Security as well. And all of this is since 2002, since the passage of the Homeland Security Act.
And this Thomas Homan is a quote that he's said, I believe it was to the Washington Post initially, and has repeated several times, that he's enthusiastic about the culture of intimidation that ICE has been propagating along with Customs and Border Patrol. In case it's not on your news feed, there's been all manner of horrible incidents of ICE lately. They targeted a woman in the human trafficking court in Queens and tried to arrest her in the court itself. They've been putting an awful lot of pressure on middle and high schools out in Nassau County and trying to sort of generate completely specious evidence of gang affiliation of the students and get records for the students. They are regular attendees at the Brooklyn Criminal Court. One of the public defenders in Brooklyn Defender Services was taking pictures of them and tweeting about how they were kind of wandering the halls looking for people to grab up. They dress in plain clothes a lot of times and can look exactly like a kidnapping if they're trying to pull someone off the street.
So just to reiterate, in terms of these different agencies, all of these agencies also are broken into parts, right? Yeah. It's hard. We have a chart, but it's impossible to fit on a slide of how all the sub-agencies within the agencies works. But what's good to know is the U.S. Customs and Border Protection, everyone calls them the Border Patrol, and there is a sub-part of them that is the Border Patrol. So those are the men and women at the airport. I know you had a nice talk with them, right? And so those are the people, if you're flying with a passport, right, they would be the people inspecting your passport. They'd also be at the southern or northern border if you're driving a car across. That's Customs and Border Patrol, part of U.S. Customs and Border Protection. Citizenship and Immigration Services, Geoff talked about them. They're the forms people. It's the benefit side of immigration. They handle things like asylum applications, right? They have a division that's the Refugee and Asylum Corps. Also everything about adjustment of status or green card applications, naturalization, work permits, everything like that would be through USCIS. And then ICE, right? ICE, the part that Geoff was talking about, that's their enforcement arm, or ERO. Those are the men and women that actually go out to the communities and arrest people. They also have a assistant chief counsel. That's the trial attorney part of ICE. So when you're in immigration court, your opposing counsel is actually going to be ICE. It's going to be a trial attorney who's within that same agency as the enforcement part of ICE, but the agency also has, tens of thousands of people working for it, really has no direct communication with that person. Is everybody confused yet? Yeah?
Yeah.
Okay.
Yeah.
Right.
Yeah.
Okay.
That's good.
Are there any questions so far?
Yeah. Okay.
All right.
They come. Yeah.
We'll keep going.
Yeah.
This is confusing. Yes, we all admit it. But if questions come up, please don't hesitate.
All right. So I wanted to talk about some similarities to family matrimonial court. So there are incredibly loose evidentiary standards in immigration court. It's pretty similar to the family courts that I'm sure you've practiced in, where there's none of this fancy laying the foundation sorts of things. Like, things are sometimes literally handed to the judge at that moment. It's also incredibly discretionary. The judges hold an absurd amount of power in terms of the kinds of benefits that they can give out, in terms of the kinds of procedural penalties that they can give onto people. It's very fact based in that there's obviously an entire school of law around all of these things, but everything really does come down to being able to prove up to your evidentiary standards and meet the criteria. There's due process. In theory, something that happens a lot, that we see an awful lot of, are people who have been ordered deported in absentia. That's when someone doesn't appear at their immigration hearing and they're ordered deported without ever actually being there. It happens an awful lot when people are picked up at the border and they're put in detention, which is basically jail, for 2 weeks to 2 months, and then are in a court in Texas or Louisiana. And then when they finally leave detention to go stay in New York or California or Chicago or wherever they're going, they alert ICE that they're going to be leaving, but they don't put in for a change of venue. And then the court in wherever they were just keeps going, and they're ordered removed, even though they've never really understood the process that they're involved in.
And to blow your mind even more, real quick, is the idea that the majority of people ordered removed actually don't even see a judge. So even if they'd showed up, they would be in a different process, something called expedited removal. This is kind of the advanced section. We're not going to go too much into it, but people who show up at the border who don't have documents, right? Someone who's going to seek asylum, who's going to seek protection in the United States, or their documents are defective, will basically be pushed back out of the United States. There's no right to see a judge for those individuals. The Customs and Border Patrol officer needs his or her signature and a supervisor's signature in order to give that person a removal order that could bar them from coming to the United States for 10 years. That's the majority of removals. The lucky ones are the people who are in actual removal proceedings. It's under different sections of the INA, the Immigration and Nationality Act. Regular removal proceedings are Section 240 removal proceedings, and those are the people that Geoff was talking about, people who might have an in absentia order, right, because they never received notice, it got lost in the mail, bless you, all various reasons for why people don't show up for immigration court, and that kind of thing. But just so that you know, the majority of people actually don't even have that right to see a judge.
And in many cases, there's a lot of reports of people being turned away by Customs and Border agents without even the paperwork to show it. The border agents will literally just say, sorry, we're full, you have to leave. And they're,
Oh, I'm so sorry.
I
totally forgot about you.
Yeah.
Yeah, please. Okay.
what's the difference between EOIR versus ICE court? Is it the same thing?
Yeah, there's only one court.
Just one court.
There's one immigration court. It is the Executive Office for Immigration Review, or ER. The court is through that. So in the court, you have, I'm going to say you as the advocate, right, as the attorney for the respondent. Our non-citizens would be called respondents in court. Your opposing counsel, that's ICE, right? ICE just has different, again, these are all big agencies, and so they have their trial attorney branch. You could think of it as the prosecutor. Again, we're talking about civil proceedings. There's nothing criminal here, but the best sort of analogy would be the prosecutor. That would be ICE. Did that answer your question? Yeah.
Right. And, oh, sorry.
The law notes that publish immigration cases, our association publishes a lot of the circuit decisions.
Yeah.
It looks like the BIA cases just rubber stamp the immigration judges, who then get rubber stamped by the circuits.
It depends.
Yeah.
So,
It depends.
talk a little bit about that.
Yeah, it depends on the case. I can't give you a statistical thing of this is how many times it happens. It really depends on the case and what you're arguing. And the whole kicker for immigration is very few decisions are actually published. So I've never had a published decision. I know one colleague who's had. Majority of decisions are not published. So in the few that are published, right, the few that you're going to be reading about, that's a minority. And sure, some are rubber stamped, but some are overturned. And that's where we make case law for immigration. So it really just sort of depends on more of the nuanced issue. Yeah. You have the most important point.
Yeah, and the most important point is that you have no right to counsel because this is a civil matter.
So you have, I'm just going to clarify, you have the right to counsel.
You have the right to counsel. You
But-
do not have the right to government-appointed counsel.
Exactly,
Yes.
right? And so for most people, that's a complete farce.
Yeah.
I used to represent children. Geoff does as well. And you can be put in immigration removal proceedings at any age. I had a 5-month-old that I was working with. He was in removal proceedings on his own. Now, even if he was the most brilliant 5-month-old ever, and you know, he was a pretty cool kid, right? There is no way that a 5-month-old can hire a lawyer, right? The kid couldn't even talk. I remember being in removal proceedings, right, with an immigration judge, and the baby's crying, right? And she's like, you know, Ms. Hannes, can you please remove that crying baby from my courtroom? And it's like, okay, cool, sure, Your Honor, I can, but this is the respondent. The record needs to reflect that she showed up. Or like Geoff said, she's going to be ordered removed. Like you can't kick her out because she's crying. You made the choice to have her in the courtroom. So there is a right to counsel,
Yes.
right? But not at government expense. And for most people, this ends up exactly as Geoff said, as there is no right to counsel because these are civil proceedings and not criminal proceedings. So even if you're 5 months old, or even if you're 88 years old and you don't speak English and you are, you know, you have a health issue or you have been through all kinds of traumatic experiences, good luck finding a lawyer, and good luck finding a lawyer if you're in detention, because it's very, very, very difficult.
And while New York is making steps
New York's great, yeah.
to provide counsel for people who are detained,
Yes.
You can see that by the time you're detained, the level of difficulty just keeps going up in terms of your ability to advocate for yourself, right? It's like immigration law I found is like a very ounce of prevention is worth a pound of cure sort of situation. And the longer cases go on, the more power ICE has over the individual.
Yeah.
And who has what rights? So there are several constitutional rights that apply theoretically to non-citizens, but whether or not ICE or Customs and Border chooses to acknowledge those rights, I feel like is a better test to whether or not they actually exist than any constitutional doctrine about what winds up happening. I could tell there are all manner of horror stories along every particular axis between searches and seizures and people being, people's homes being gone through all the time. Ideas of cruel and unusual punishment. So being in immigration detention longer than 6 months without a bond hearing is considered to be cruel and unusual. I know hundreds of people who've done longer than 6 months before getting a bond hearing.
And that's just in New York.
Yeah.
In other states, it's not cruel and unusual, apparently.
Yeah. There's an entire for-profit industry that is connected to detention that provides ankle monitors, the shackles, for people in order to bond out. Those ankle monitors often heat up to the point where they burn people. They cost $400 a month in order to pay this private company to allow you to bond out. So in terms of substantive rights, it's pretty thin.
Okay.
And with that cheery note.
Questions so
Yeah.
far? Yes, ma'am.
What are the detention centers like?
A jail. It's
Yeah.
equivalent to a jail. Your client wears, I guess, let me back up. So there is a bed quota. It's about 44,000 people a night that have to be in immigration detention. It's a congressional mandate that came in about 2009, 2010. It used to be 34,000. Now it's at 44,000. So in order to find that space, there is the private prison companies that Geoff talked about, Core Civic. It used to be the Corrections Corporation of America. GEO are the big ones. Their stocks are doing phenomenally well. They contract with state and local prisons in order so that there's enough space. So all in New Jersey, right, at all the local prisons, there will also be an immigration detention arm to that prison, upstate as well, right?
It's literally a floor in Elizabeth.
Yeah.
It's like the third floor is just.
So it looks the same as a jail. People wear different colored jumpsuits effectively. And then I've been in the family detention centers in Dilley, Texas, is where women and children are kept. And while they're not wearing jumpsuits, they're wearing, ordered, like prison issued sweatpants and sweatshirts. So they're not free to leave. The medical care is abysmal, if anything, and it is effectively a prison. Yes.
This may be a little beyond the scope of your presentation, so if it is, just tell me. But I'm interested to know how do the constitutional rights differ between a non-citizen immigrant and a U.S. citizen, as far as like due process and the Fourth Amendment, things like that. Like, do they have rights to border control? Border patrol have rights to search immigrants on U.S. soil that they wouldn't have against a U.S. citizen?
Depends on where you are physically. If you're at a border, this is my exhibit right here, you have the right to, immigration has the right to do just about a lot, right? In terms of searching devices. If you're a non-citizen, it's going to be a non-U.S. citizen, right? It's going to be a lot, I don't say easier, it's still tough, right? Because you might still spend the night in jail, or you might have your cell phone confiscated. But if you're not a U.S. citizen, you for sure are going to detention if you're giving Customs and Border Protection any junk about not being able to access your electronic devices. So in terms of your person, what you're carrying, everything at a border, as a non-citizen, you effectively have no rights. As a U.S. citizen, your rights are very limited at international borders and ports of entry. In the interior, it depends. As a citizen, I think you do have more rights, and I think, there's different case law that goes both ways. But the idea is, this whole idea of expedited removal actually is how many miles you are from a border. So if you're within 100 miles of a land border, and then there's courts that talk about an international airport also being a border. So pretty much everybody's 100 miles from something. It gets really scary when you're talking about if your rights are more limited if you're a non-citizen. So I don't have a good answer for you yet. Hopefully there'll be better case law that at least I think hopefully would clarify that everybody has the same rights.
Are there significant
Yeah.
Due process differences in due process rights?
I mean, the right to further judicial review, right? The right to a habeas action. You actually don't have that as an arriving alien, is what the statute says in the Third Circuit. And to me, that was extremely problematic. Yeah.
And again, you only have as much rights as you're able to effectively advocate for.
Yeah.
Scary fact. So I am in private practice now. I pay about $100 a month for malpractice insurance. I've only been practicing a couple of years. I've talked to colleagues who've been practicing for 20 years and run a firm and do all these things, and they pay about $100 a month because immigration attorneys don't typically get sued by their clients, because if we mess up bad enough for you to get sued, you probably aren't in the country.
Okay, so how do we keep you in the country? Let's
Right.
see. All right, common forms of immigration relief. I'm sorry, we're just doing
No, it's
down. Thank you. Okay, So we're going to do a big overview of what is a semester-long course in law school. So I hope everyone's got their pens, pencils, computers. There's a quiz at the end. No, I'm kidding. Don't freak out. But this is an overview. So clearly, if you have further questions, we're going to hang out afterwards. And if you want more knowledge about any of these items, let us know. We can suggest supplemental readings. So in our big wide world of immigration, there are various paths for people to obtain what is lawful permanent residence, to become an LPR. What that means is someone who has a quote unquote green card here in the United States. Right now, green cards are green. In the past, they've been all different kinds of colors, right? But the idea of someone who is a green card holder is a lawful permanent resident. And someone who is a lawful permanent resident can then apply to naturalize, which means to become a U.S. citizen. Okay, so what are those paths? We have employment, we have family, we have something called the diversity visa lottery, we have the humanitarian path, and other sort of things like cancellation of removal, that's sort of the more sophisticated path, certain forms of immigration relief that you're going to see really just in immigration court. So we're going to focus more on the family and the humanitarian side. That might be most of what you're seeing in terms of your practice as family matrimonial, but also just so that you know, employment is also out there as well. There are many, many, many people who have employment visas to come to the United States. Some of those are non-immigrant visas, meaning they are for a limited time and they do not turn into a green card. Others are ones that are immigrant visas based on employment, and with those, through the employer, can sponsor that individual to actually obtain lawful permanent residence in the United States as well.
A great kind of theoretical framework that someone once told me is that it's useful to think about all sort of immigrant and non-immigrant visas and relationships as having some sort of benefit to a U.S. citizen.
Yeah.
Right? So employment, obviously, or people who come here on student visas or tourist visas, they're here and they're buying things and they're going to school and they're doing something that's locating around the U.S. citizen's rights. Same thing with family, right? Humanitarian's a little bit different because it touches on our international obligations, but just conceptually, I've always found it really helpful to think like, okay, so how does this person help a U.S. citizen and how do I show that?
Yeah, cool, great. Okay, so family-based. Family-based petitions allow U.S. citizens and lawful permanent residents, again, green card holders, to sponsor family members so that can permanently live and work in the United States. It's a two-step process. One is, okay, again, immigration has filing forms, right? So here's a form. When we're talking about forms, we're talking about USCIS, right? We're talking about the benefits agency. So the person who is the sponsor, so that's the person who is the U.S. citizen or the green card holder. They are also called the petitioner. They petition for the beneficiary, that's the immigrant, and they have to establish that relationship. So if it's marriage-based, they are proving that that is a good faith marriage. So many of you might ask, well, how do you prove that to immigration, right? Love is not the standard here. I do this with my law students. They're all like, we prove we're in love. And I'm like, that's great. Nobody cares. It is that you have the intent to establish a life together. So commingling of assets, the fact that you live together, if you have children in common, whether they're biological, adopted, all of those kinds of things. If you had a ceremony, if for your wedding, if you are the joint beneficiaries on anything like that, all of those would become the evidence you would need in a marriage-based case, in addition to actually being legally married. So with that, you would then, if the person was in the United States, be able to file for adjustment of status, which is the green card petition. If the person was abroad, the immigrant was abroad, they would do something that's called consular processing, meaning that the person would go and pick up their visa to come to the United States at a consulate in whatever country they were in. Okay, so just so you know, there's two levels. The quickest route is for people who are considered immediate relatives. So these are very special people in immigration law. And only U.S. citizens are allowed to have immediate relatives. Green card holders don't have immediate relatives. They just have relatives. And not all your relatives are your immediate relatives. It's only a spouse. You only get one, right? One spouse and your unmarried minor children under the age of 21, as well as your parents. These are the special people that are immediate relatives. And why they're special is there's no line to stand in. Effectively, as soon as that application is processed and filed, and there is a time for processing, but there's no quota delay, there's no line. all of these people effectively could come and immigrate to the United States, assuming that the person who is the citizen could prove to the U.S. government that he or she could support them at a certain percentage of beyond the poverty level, right? 150% of the federal poverty guidelines. Questions? Yes. Exactly. So for immigration purposes, same-sex marriage is 100% okay, right? In terms of immigration, the only issue would be if the people were, if the country where the individuals are from, more often this comes up in asylum cases, if they weren't able to get married in that country because same-sex marriage was not legal in that country, and then applying for that person if that person couldn't get out of that country. So that's the only trick. But for immigration purposes here in the United States, there is no problem.
Something that comes up a lot with these is that 150% of the federal poverty line for the household. You're able to get fiscal sponsors. So if you have a couple that their combined income doesn't make that much money, they can have additional people co-sponsor and say that they'll ensure that the arriving immigrant doesn't become a public charge.
Public charge.
Yeah, that they will not be taking any of those benefits.
That they won't be eligible for anyway, but effectively is public charge. Just so that you know, that thing is called an affidavit of support, and the only time that is divorce doesn't give away the obligations on the affidavit of support. So in a perfect world, we would also tell that person to go get an attorney to look over that affidavit of support. 0% of my clients have done that, right? No one. Right. Not a lot of people have this magical immigration attorney on standby, but just so that you know, divorce, it's only really death or the U.S. citizen becoming, the immigrant becoming a U.S. citizen that would end the obligations in the affidavit of support. Andy.
On the bringing in other fiscal sponsors, can they just be anybody?
No, they have to be a green card holder or a U.S. citizen, 18 years of age or older.
But they don't need to be related.
Exactly. Yeah.
Since LPRs are eligible for certain public benefits, if an LPR, someone comes here and becomes an LPR and gets public benefits, does their sponsor then become responsible for that money paid out by the state?
No, because they would only be eligible after usually 5 years. They have to be an LPR for 5 years before they would be eligible for those benefits. In that 5 years, they could also naturalize. So the 5 years would end the sponsor's obligation, and then it would be that person's choice, unless there was some reason why they didn't want to naturalize, to naturalize, then that wouldn't be a problem. If they're getting benefits because the agency didn't double check or something fell through the crack, yes, then that could be a problem. But theoretically, they wouldn't be eligible. Yes, sir.
Are there restrictions as to who can serve as a sponsor?
Yes, right. Green card holder, U.S. citizen, over the age of 18. Nope, any person. Yeah.
Is the obligation in the affidavit of support indefinite?
No. So death of either party. Yeah, that sounds morbid. Death. Okay, death ends it. The immigrant becomes a U.S. citizen, or a certain period of time goes by. It's usually 40 quarters of work, or the 5 years, which I was explaining to the person in the back, in order to for them to have been here so that they'd be eligible for public benefits. Yeah, Andy.
There's also a follow-up clause that lets people get out of it as well.
Pause.
No spoilers. We're getting to follow.
Spoiler. Yeah, we're going to get to. I'm sorry. I'm going to start with the overview. Andy's exactly right. We're going to talk about different sort of humanitarian protections in a minute, but totally cool, right? So if there's domestic violence, right? If there's anything like that, that for sure is a different sort of situation for people who are not in a domestic or an intimate partner violence situation. That would be our standard here. Okay, super. I'll keep going. Okay, great. Here we go.
It was more of a trailer than a spoiler.
Exactly. Okay, so domestic violence and immigration, sure. So survivors of domestic violence can also obtain residency based on familiar relationships. Spouses and children in abusive relationships can take the abuser out of the process and file what's called an I-360 self-petition in lieu of the I-130. So what does this mean? In a domestic or intimate partner violence relationship, the idea that the abuser, who in this case the abuser would be the U.S. citizen or the green card holder, is ever going to file for the person he or she is abusing is false, right? With the idea of power and control, you being the person in power means you for sure want the person you're abusing to remain an immigrant to remain undocumented, to remain totally under your control. So what sadly you see, or what I see a lot in my practice, was the idea of the victimized spouse, right? The survivor of the violence had been married for many years to the U.S. citizen, in this case for my clients, the U.S. citizen husband, and he never filed those papers for her. He told her they would. They started preparing them. It never happened. So with abuse, she can file what's called a VAWA self-petition. VAWA stands for the Violence Against Women Act. It applies equally to men as well. It just has women in the title, but that's it, right? You can just insert men. It's the same law. Came out of a Clinton crime bill in 1994 and has actually been reauthorized and expanded since then. So what does that mean? It means that the immigrant has to be legally married to the U.S. citizen or to the green card holder, and has to be a survivor of abuse by that person. This is also for same-sex couples as well, right? So the idea that the spouse of the abuser may self-petition if married to the abuse of U.S. citizen or green card holder, and also unmarried children under the age of 21 who are immigrants can be included as derivatives. Okay. Also, in terms of an elder abuse type thing or a parental abuse type thing, if the idea that if a child is abused or if a parent is abused by a U.S. citizen child, and for immigration step parents or stepchildren, the whole Cinderella thing, that doesn't apply in immigration. If there actually is a valid step-parent relationship, that's the same as effectively a parent in immigration law. So if there's abuse by the child against the parent and the child is a U.S. citizen, VAWA actually can work for that as well. It's very rarely used for that, but just something, to keep in mind, keep your antenna up in case that comes up. So the child also in this case who has been abused, so either way, the parent can petition, or a child who has been abused by a U.S. citizen or green card holding parent could also apply for protection under VAWA. This would enable someone to get work authorization as well, and depending on if the abuser is a U.S. citizen or green card holder, if the person is a U.S. citizen, when VAWA is approved, the survivor can then automatically petition for his or her green card. If the person is a green card holder, then the survivor might need to wait in line a little bit. It depends on something that's called the visa bulletin. That's in our advanced class, the next show. But in general, there's a line, right, for people who are green card holders. And so that person might have to wait in line until it's his or her turn to apply. But it gives people a pathway to a green card, which is then a pathway to U.S. citizenship.
Other, I think, general important notes. You have 2 years to get divorced from the filing of the VAWA, so they don't need to already be divorced or even have begun those proceedings necessarily.
You don't have to be divorced at all for VAWA to work. No, actually. So if you are divorced, you have to file VAWA within 2 years of your divorce.
Sorry.
But you don't ever have to get divorced for VAWA to work. You can remain married to your abuser forever, right? If you do get divorced, then you have only 2 years from the date of the final divorce decree to apply for protection under VAWA. Yeah. And then for public benefits, I just want to reiterate what Andy said. There are for people who are survivors of domestic violence, who, let's say, this person is getting a green card, there are different types of public benefits, and a whole other segment is immigrant access to public benefits. It's something near and dear to my heart. The person wouldn't be able to get food stamps, but would be eligible for cash assistance. If the person was under 18, then he or she would be eligible for food stamps. It's just because our law is kind of crazy. There we go. Yeah. Yeah.
What kind of proof does somebody have to show in order to qualify as abused?
Great question. What kind of proof does someone have to show in order to qualify for abuse? So in VAWA, an affidavit alone, right, from the survivor could be enough in a VAWA case. We're going to get into something called U status or a U non-immigrant visa, and a little bit there you need actual sign-off by an enforcement authority. That could be the police department, that could be a family court judge, that could be a DA. For VAWA, there's no sign-off, right? No one's signing anything for a VAWA self-petition. It is helpful in addition to the affidavit of the declaration herself or himself of the person being abused, that perhaps he or she has seen a social worker, has seen a therapist. If there's medical records, if there are police reports, anything like that, that's helpful, but you don't have to have it. Yes?
So if there's no abuse in a United States citizen spouse or immigrant spouse,
get citizenship or green card or whatever for the married.
Yeah, I mean, theoretically they do it together, but it is the petitioner is always the U.S. citizen and the beneficiary is always the immigrant.
The American's responsibility to do the paperwork.
I don't know if you say responsibility. You don't have to ever petition for your spouse, really.
Say to the spouse, do it.
Okay, this is the only way. Exactly. So
there's no abuse.
if there's no abuse, but in most circumstances, if the spouse wanted it filed and he or she is not filing it for them, there could be something else going on there, right? That might rise to the level of abuse. Yeah. No, exactly. Yeah. But does that make sense? I mean, yeah, most people, it's a talk between the couples and they figure it out. And yeah.
Sorry, the follow-up question that I had was, I seem to remember there being a term in VAWA about getting out of an affidavit of support.
Okay, I misunderstood.
The immigrant spouse is abusive towards the citizen or permanent resident spouse.
Well, okay, so it wouldn't have been the immigrant's affidavit of support; it would be the abuser's affidavit of support.
This is
okay.
I had a case like this a little while ago, and I did some looking it up, and I didn't really understand.
Yeah.
If the immigrating spouse is the abusive spouse, is abusive towards the
U.S. citizen.
The citizen spouse.
Okay.
There's a VAWA clause to
okay.
get out from under your affidavit of support absent death or the 5-year
okay.
rule. If under VAWA, if the immigrating spouse is abusive.
I have no idea because I'm the other way, right? I'm the immigration attorney. So I don't care about the U.S. citizen who's the abuser. I'm like, that person should go to jail, right? I'm on the other side. So my thing is sue the abuser, right? I'm on the other side there. So I don't actually know. I've never represented the U.S. citizen. I'm only representing the person being abused, which for a VAWA case in the immigration context, the person being abused is the immigrant. Right, VAWA is huge and might certainly have that. I just don't know because. Yeah, exactly. That's a matrimonial issue. There you go. Yes. Yeah, good moral character is part of VAWA. Yes, exactly. So for some people, VAWA might not be the solution if I want to call the person the survivor. If the survivor has a criminal court record, has something very serious where he or she might not be able to show what's called good moral character, kind of this huge amorphous term in immigration, then there might be the idea for U status, U non-immigrant visa. We're going to talk about that in a little bit. Or the idea that if the criminal matter was directly related to the abuse, sometimes you see forced, like prostitution effectively, something like that, and that was the abuser forcing the survivor to do that kind of work, VAWA is going to waive that. That's not going to be a problem. But if it's, or I've seen also the idea of having to steal things because the abuser made he or she do that. If it's explainable, yes. If not, maybe not. Yeah. Okay. Yeah.
Is the standard to qualify as a victim of domestic violence in this context similar to an order of protection in family court, such that, if you have some police reports, if you could get an order of protection, could you also qualify for VAWA?
If you get an order of protection, for sure you can qualify for VAWA. I also did orders of protection, and I would say it's actually lower than that.
Okay.
I could see it be lower than a family court order of protection than that standard.
Probably similarly, there's often in family court, there's often more of an emphasis on domestic violence being that old-fashioned idea of a punch in the eye, black eye, as opposed to
here we
harassment,
have emotional, economic, sexual, physical for sure, right? All of everything that's in your wheel of power and control, right? Go through everything, and then put immigration status in there as well. So for sure, part of the power and control is going to be, I'm going to call ICE and have you deported, which today, right now, it always was a real threat, but today that's beyond a real threat. That's the abuser, he or she could actually make that happen. Yeah. Okay, we're going to move on. Okay, humanitarian forms of immigration relief. So we have a lot here. We're going to cover them quickly, and then you're going to let me know if you have questions. Great. So asylum, withholding, and protection under CAT. CAT stands for the Convention Against Torture. So Geoff talked about these a little while ago. These are our international obligations Withholding of removal and CAT being for sure 100% international obligations that the U.S. signed on to after, sadly, the Holocaust, and then came into law in the 1950s, were actually codified in 1980 with the Refugee Act. Asylum is the most generous, then comes withholding, and then finally CAT. CAT is for people who are afraid that they would fear torture if being returned to the countries for where they are from. Oftentimes you will see this used for people who have committed very serious crimes in the United States, where they would be barred from both asylum and withholding because of their criminal convictions in the United States. They might still be eligible for CAT relief depending on where they're from. So you see this more in a criminal law context, but just throwing it out there in case this applies to your clients as well. CAT is a limited form of protection. There's not a lot of benefits that you get with it, but you don't get deported back to that country from which you're from once you served your jail sentence or prison sentence, in the United States. Asylum, most generous. Withholding, I'd say second most generous there. Refugee resettlement. So a lot of people use the term refugee without referring to its legal definition. It does have a legal definition. I won't bore you with it right now. It's long. But the idea that there are certain groups of people which our Trump administration has put an end to, sadly, but that are resettled here in the United States as refugees. So the minute that person steps foot on U.S. soil, they're coming through airports, they are designated a refugee, which is a legal status that puts them on a path to a green card and then to U.S. citizenship. So that is someone who is resettled here as a refugee. People who are seeking asylum got to the United States, no matter how they showed up, they physically got to a port of entry, so an airport, a border crossing, or they're magically here inside the United States, and then they're applying to be a refugee in the United States. If they're granted, they become an asylee. That's someone who's granted asylum. Does that make sense? So same definition for both. Refugee, it's all done abroad. That person comes here through a whole lot of ways, or used to come here, I should say. It's just so sad, I can't even, right? Used to come here. Asylum, person is here either out of status or they have some other type of status, a student visa, something like that, and then they're applying for asylum here within the United States or at a border. Okay, withholding the same. You have to apply for that here in the United States. I saw your hand first and then the lady. Okay, yes.
Sorry.
Yeah.
What is the difference between withholding of removal and asylum? Because I do pro bono work for representing asylees, and I assume they're asylees, but we're pulling out the withholding of removal application.
Okay, so yes, so asylum, it's the same application, it's the same form that Geoff talked about, the form I-589 that you're going to fill out. The difference is the legal standard, whereas asylum, you can have suffered from past persecution, so really bad things happened to you in the past on account of your race, your religion, your nationality, your political opinion, or your membership in a particular social group. Super, that's our definition, right? For withholding, it's future looking. So asylum is bad things happen in the past, or you have a well-founded fear of bad things happening on account of those protected groups in the future. Withholding is only future looking. It's a more limited form of protection. It doesn't put somebody on a path to a green card. And where it's normally used is for people who are barred from asylum, most likely because they missed the 1-year filing deadline. For everybody except for certain kids, there is a 1-year deadline to filing for asylum unless you meet certain changed or extraordinary circumstances. And saying, I didn't know that there was asylum protection isn't a changed or extraordinary circumstances. So if that person was granted asylum, he or she made it within 1 year of last entry for filing, or was able to overcome those two things.
So if someone misses the 1-year deadline, they would have to show that conditions changed in their home country?
No, if someone missed the 1-year filing deadline, they have to show that they are afraid to go back to the home country on account of one of those 5 grounds.
But if that was the same ground, they would have applied within the 1-year deadline.
They might likely be granted asylum.
Then can they show something else to make up for missing the 1-year deadline?
No, there's nothing else. You are barred from asylum unless you can show changed or extraordinary circumstances.
Okay.
So if you missed the 1-year deadline because everything was great in your country, and then all of a sudden you were here on your student visa going to law school, and then there was a civil war and your father was murdered because he was a political activist and you can't go back, yeah, okay, so that would be an exception to the 1-year deadline.
You can also argue disability, both physical and emotional. It's something that I worked on a lot at Immigration Equality, where people who were severely traumatized, and so we would get social workers and other mental health professionals to say that this person was not capable of applying for asylum up until this point.
Exactly.
And so that was a way to get around.
And that can be successful, right? I've had cases, Geoff had cases where that's successful, but average, I didn't know about asylum isn't going to be enough. Yes. Okay. Yes, ma'am. Okay. We're good. Cool. Okay. Yeah.
Question. Did I misunderstand you that asylum is only past persecution, but not a well-founded fear of future persecution?
Or. You can have both. Great case, right? But you only need one or the other. Your ideal client, sad to say, has both. And you're like, great, we got it. Yeah, Andy.
So asylum is a path to citizenship, and withholding and CAT are not.
Perfect. Yes, perfect. So what Andy said, I'm just going to repeat it. Asylum is a path to a green card, and then that becomes a path to U.S. citizenship. Withholding and protection under CAT are not. They are indefinite statuses. You can have that forever. With withholding of removal, you'd be granted some access to public benefits. CAT as well, though more limited, but that doesn't put you on a path to a green card. And exactly what Andy said, that's not a path to citizenship.
It's sort of like whole 2% and 1%. There's a lot that you lose going down to withholding your CAT.
Yes.
Because visas no longer exist?
S, the snitch visa. Yeah, they're always there, but all three people that get them, I don't really talk about them. So letters of the alphabet, visas. Cool, great. S is a visa. It's for, we call it in immigration law the snitch visa, right? It's for people that have been helpful to different types of crimes. It's like very few people. I don't know any practitioners that have had anyone granted an S visa. It's very, very rare. So I don't talk about them because the chances of you seeing that are very rare. If you do, you're going to email me, and then I'll know you, and then you'll come talk in my class, and it'll be great. Cool. Okay, UNT, you will see these. These will be your clients, as well as asylum and refugee resettlement. Let me just see. Do we have these written down? Sorry. I think do. Okay, great. And Stitch. Okay, so asylum, great. We talked about this. Super. And sorry, I'm going to go back to asylum. One thing we didn't talk about is the idea of derivatives. With asylum, your spouse and your unmarried children under 21 at the time you file, they get granted asylum too, just like your client. For withholding and with CAT, they don't. There's no derivative benefits. Okay. Asylum, withholding. So withholding and CAT are basically the least that the U.S. has to do and still be in accordance with its international treaty obligations, right? The international treaty obligations that the U.S. signed on to are we won't send people back to be tortured. That's exactly what the U.S., the minimum, right? There we go, doing the minimum. Okay, super. So U visa is available to victims of certain criminal activity. We're going to talk about what certain criminal activity means, have information about the crime, have been or are likely to be helpful to law enforcement, and have suffered physical or psychological trauma. Super. This is the list of the certain criminal activity. There's 26 enumerated crimes. These are all on the USCIS website, that benefits agency. They actually explain U and T status very well on their websites. If you need something to read on the subway home, why not Google it? Have a look, right? These are fairly new. U and T are the newest of our immigration humanitarian remedies. So they actually put some effort into the website to make this readable. Okay, so these are the criminal activity. You might be saying, okay, well, domestic violence, how does that work? There's no crime of domestic violence, right? It's broken down into things like assault. Yeah, that's fine. This is, again, we're talking about everybody in all the different states. Some states do have domestic violence as an act in their penal code, but here, right, you'd break that down. But just so you know, right, we're talking a lot of times about crimes of violence, but there are white-collar crimes on here as well, sometimes a little bit more difficult to show physical or psychological harm if you are a victim of perjury or of blackmail. But in general, right, just to keep that up there, extortion, things like that, it could be there as well. And crimes have derivatives. So you see murder up here. So clearly, if you were murdered, you're dead and you can't apply for a U visa. However, right, the person who witnessed that, or your very close family member, your mother, right, someone like that who was deeply impacted, she might be able to apply for the U visa. So to, think about that as well, right? Yes.
Guidance provided also says if it's a substantially similar crime.
Perfect. Thank you. Exactly. So yes, thank you. So felonious assault, sometimes we don't have the felony, we have a misdemeanor, but it's charged as a very high misdemeanor. Things like that, sometimes you'll get that signed off by law enforcement as a substantially similar crime.
Speaking of law enforcement, the Brooklyn DA's office has really made an effort to reach out to immigration attorneys and legal service providers to help facilitate this relationship, because obviously if you're of a population that has a very good reason to be afraid of the police, you're not really inclined to go down to talk to the Brooklyn DAs. But they've been great. I have a couple of contacts over there that we can share with.
Yeah. So every agency that signs off, again, you need to have law enforcement sign off to have, or agency sign up, I should say, to have a U visa. If you don't have that, you don't have a U visa application. There's no filing it and then getting it later. In terms of certifying agencies, you have law enforcement, clearly, any police department, right? You have the district attorney. Every district attorney has his or her own procedure, like the office has a procedure for doing it, and there's a designated signer in the office. So if there's an ADA that you're working with, if he or she's new, might be like, I don't really know. Great, ask them to go to their supervisor and says who signs off on new visas and when in the process do they sign off, especially if it's going to be an ongoing investigation. Some boroughs will sign off during the investigation. Some will have to wait until the trial is over. So it's a good thing to know so that you can properly counsel your client. Also ACS, right, or Child Protective Services outside of the city, they're designated signers. Family court judges and referees for sure are designated signers, as well as Supreme Court judges in terms of matrimonial actions in which an order of protection, something like that might come up. Also the New York, I just read the Human Rights Commission, they are a signer. Something else to think about, the Department of Labor is also a signer, and we're going to talk about this when we get into trafficking as well. But there's a lot of different agencies, especially here in New York, who can sign on to this certification that your client has been cooperative. Okay, so what is U? U is really great, especially if your client has committed certain crimes. U waives just about everything except for being a Nazi, as in the olden days Nazi, like still alive, like alive in the 1940s kind of Nazi, and being an active participant in Nazi Germany. And also a terrorist. U doesn't waive that. But everything else U waives, which is super for immigration attorneys. We're like ecstatic at this, because even if our client committed immigration violations or crimes, right, U would waive that, as opposed to VAWA, which might not. Okay, U doesn't care what the immigration status of the perpetrator is. This could be a domestic violence situation in which the abuser is undocumented. Super, fine, that can work for a U, as opposed to a VAWA case where the abuser has to be a U.S. citizen or a green card holder. And again, for couples who aren't married, right, who aren't legally married, this is where U comes in as well. You for sure don't have to be married to the perpetrator of a crime under U. Okay, would put someone on a pathway to permanent residence. Basically, you have U status for up to 4 years. After the 3rd year, you can apply for adjustment of status, which means a green card, and then you can then in the future apply to become a U.S. citizen, and you can include a whole lot of people as your derivatives. This is especially important for children. If someone who is a child who is granted is applying for U status, they can apply for their parents and all of their siblings to receive U status as well. There is nowhere else in immigration law where it works like this. This is like really exciting. I'm excited. You're excited. Yeah. So child clients, like if that kid's coming up to age 21, this has to be filed before. If you want mom and dad and all the siblings to get protection, the catch is that, again, if this is a domestic violence or family violence situation, the abuser, right, cannot get protection through you. It's actually written into the statute. So just so you know. The downside with you is that there's a big, fat, giant backlog. This, I think I'm saying from April of 2016, yeah, it's still about 80,000 cases that are pending. The government gives out 10,000 a year. Right now, it's a 2-year backlog to receive a receipt notice for it, which would allow someone employment authorization. So the good news is after 2 years, your client will get a work permit, but the bad news is it'll probably take 4 or 5 years until he or she actually gets U status, then another 3 years to be able to apply for adjustment of status, and then another 5 years to actually apply to become a U.S. citizen. Public benefits are limited, but they're there once that person is in U status, so that's positive, but that's what we got. Okay, And then we'll go on to T, non-immigrant status. So this is for people who are the victims of a severe form of trafficking in persons or of labor trafficking as well. So I'm sorry, so trafficking in persons could be sex or can be labor trafficking. Both are looked at as equally severe in the eyes of the adjudicator, are present in the United States on account of that trafficking. That does not mean that they are brought to the United States, like trafficked into the United States. They could be, but it could also apply to people who are in the United States and then become the victims of human trafficking as well. Complied with reasonable requests for law enforcement unless they are a minor. If that person's under 18, they don't have to show any type of cooperation, or that person is severely traumatized. Then there's an exception as well, and would suffer extreme hardship or unusual and severe harm upon removal from the United States. Yeah.
There's a great, I'll add it to the Dropbox link. I should have done this before. There's a great questionnaire that emergency rooms use to screen for trafficking victims, and it phrases the questions in really, really important ways, like asking whether or not you've worked somewhere where the people held your ID, or were you able to get up and use the bathroom? Were the doors and the windows locked? But it has like exactly the kinds of questions that you're looking.
Exactly, because asking your client, have you ever been trafficked? Like no client ever is going to raise their hand, maybe one, right? But the majority of people don't understand what that means. That concept is of trafficking, right, isn't a common word that people know. And the idea that the crimes that happen to them fall within this definition of trafficking, they might not know that either. Okay. So there are 5,000 T visas available annually, right? Let's compare that to the 10,000 U visas. They're never used up. There's no delay. You can apply right now. If you had 5,000 clients and they were all T eligible, you could apply and probably get them all. Why is that? The idea that, again, it's very hard to identify people who are being trafficked, right? So if you have a client for which this might work, or a client that it could be trafficking, it could also be you're going to go for trafficking. Not only is there less of a wait time, but the idea that access to public benefits for someone who's granted a T visa, even before they're granted a T visa, while they is just pending, will be eligible for absolutely everything in types of public benefits, the same as someone who was granted asylum or was resettled here as a refugee. It's much more limited, and that's only when you're granted U status after, 4 or 5 years. So T, right, if all things being equal, that would be the way to go. Again, path to permanent citizenship, the same idea of derivatives, right? For kids, you can apply for parents and siblings as well. And again, puts people on a path to permanent residence. Yeah, Andy.
Just to be clear, both of these visas that can include qualifying family members, only one member of the family needs to be the victim of trafficking or some other crime, and the rest of the family can just sort of piggyback on that.
Depends on how old the person is. If the person's an adult, then it's spouse and children. There's no more siblings. If it's the kid, then it's parents and siblings and spouse. If the kid 21 and under, if that young adult is married, that person can do spouse, parents, and siblings.
Even absent any crime committed against any of the other families.
Exactly. As long as they're not the perpetrator of that crime. Yes.
They don't have to be the parent.
Nope. Cool. Okay. And moving right along, SIJ, Special Immigrant Juvenile Status. Okay, so this is near and dear to my heart. I did pretty much SIJ cases only for about 3.5 years. SIJ is one of the most underutilized remedies, or traditionally, historically underutilized remedies in immigration land, meaning that the majority of immigration law providers have no idea what it is. Judges don't know what it is because it's adjudicated by the benefits agencies, so judges never see SIJ cases in their courts. Okay, who's eligible for SIJ? And just a quick note, the law changed on SIJ in 2008. So that came into effect in 2009 with the Trafficking Victims Protection Reauthorization Act. So if you're going to go Google this on your commute home and you're reading anything from 2008 or earlier, it's out of date, throw it away, don't look at it. It is now, SIJ is much more generous than it was back then. Okay, so for kids who are under 21 and unmarried, who are declared dependents on a juvenile court, reunification with one or both parents is not viable due to abuse, neglect, abandonment, or similar basis under state law, and who it's not in the kid's best interest to go back to their country of nationality, or if they're stateless, country where they last lived, they can be found to be eligible for special immigrant juvenile status, which would put them on a path to a green card. Great. So juvenile court, what does that mean? We don't have something that says juvenile court here in New York. We have 4 courts here in New York that take jurisdiction over matters concerning kids. Who can tell me one court that takes jurisdiction over matters concerning kids? Family court. Keep on going. What's another one? Supreme Court. Super. Surrogates court. One more. Criminal court. Thank you. Great. You guys got, no one ever gets all 4. I'm a good audience. Good job. I know. Yeah. Okay, super. Any of those courts, the judge or the referee from any of those courts could issue what's called a special findings order, which would outline all of these things. If you want to look at a special findings order, it's General Form 42 in our state courts websites. That is a special findings order with that order from the judge and an underlying petition, whether that's custody, whether that's guardianship, whether that's a different type of petition. That young person can then send all of that to USCIS, the benefits agency for for immigration, along with the immigration form, and be adjudicated a special immigrant, right? This cuts off on the kid's 21st birthday, meaning that it has to be filed, preferably the day before that kid turns 21. Please don't be the person that files it that day, and then we have to argue on appeal about what time the kid was born and in what time zone. Nope, no one wants to do that. Get it in the day before, and then it locks in the kid's age, right? Kids get older just like we do, and it takes a little bit of time for this to be adjudicated. But the idea is that this can afford a lot of protection to young people. So who is going to be a child that is unable to reunify with one or both parents, right? That could be kids in foster care proceedings, that could be in dependency proceedings, guardianship, custody. That could also be kids in adoption proceedings. And this is what I'd like you all to take away, is the idea that in an adoption, right, a kid could be found eligible for SIJ and then could be on a path to a green card. Just adopting someone in state court without a SIJ order does not put them on a path for immigration purposes to citizenship. International adoption, meaning the immigration part of adoption, is super duper complicated. Again, that's the advanced course to be scheduled at a later date, but just a state court adoption doesn't give anybody immigration benefits. So the idea that is so prevalent in our family courts, again, before the Trump administration, with this idea of benign neglect, where we don't ask our clients where they're born and all of that. For SIJ, right, if you're representing the kid, you got to ask the kid. It's not okay for, if this is one of your clients, right, that you also didn't do the work to get that kid a special findings order that he or she could have used to get a green card. It's just very sad when I see people who are over the age of 21 who were in dependency proceedings or who did have an adoption, and this could have been their pathway, but the lawyer didn't know, right? SIJ is coming up more and more. It's more and more well known. So please don't let this go for a young person, because it can transform their life from being undocumented to having a green card. If you're undocumented, you can't get financial aid, right? With a green card, you can. In terms of a work permit, all that, it really, truly makes a difference in a young person's life. Questions on SIJ? Yes. Yeah, so kids from those 4 countries, sometimes Mexico and China are on that list, it just depends. They're oversubscribed for the adjustment of status part. So SIJ, 2-step, just like family-based petitions, right? You file for the actual petition establishing that you're eligible, and the second step is filing for a green card. So for their green cards, it's going to take a while for kids in those categories, but anyone at any time can file this special immigrant juvenile status petition. Doesn't matter what country you're from. For those kids, because of the way Congress allocates visas to a certain amount of people from a certain country, those countries are oversubscribed right now. Yeah. Go. Yeah.
What was I going to say? Because this is a family court located issue, all of the abuse, neglect, and abandonment all follows New York family law. So it's 6 months no contact, things like that. It just tracks all of that case law. A constructive neglect that's used sometimes is not sending children to school, which often happens in Northern Triangle countries, not because the parent is neglectful because they don't care about their child's education, but because it's a very dangerous place to send them to school. So it is possible to use that as a route to get SIJ. What was the other thing I was going to tell you? If you have any interest in these, there is a tremendous need, and immigration attorneys generally are terrified of family court.
Oh yeah, for sure.
So particularly, this was like part of the reason that I wanted to make sure that like there's some crossover between family and matrimonial attorneys and immigration attorneys, is that immigration attorneys are incredibly intimidated to go to family court and be involved in any family court matters at all. And I can introduce you to, I think of a dozen off the top of my head, immigration attorneys that would love to collaborate with someone that works heavily in family court matters on these sorts of cases.
Yes.
What's the position of the family court judges? Are they receptive to make these special findings?
Yeah.
I've heard anecdotally that that some people feel that this is a back end to legalize these kids, and that there's some reluctance.
Yeah, I think it depends. It's a great question. It depends on the court and it depends on the judge, right? So for sure, right, you'll have judges that have been said to me, right, this is political and I won't do it. And I'm like, okay, cool. Well, your boss said you had to, right? If we're going to argue about it, that's great. But this is a general court form in New York State, right? And who decided that? That's your boss, Your Honor, right? That's the Office of Chief Court Administrative Judge, whatever it's called, right? This isn't a political choice for you to make. And the whole idea is, right, I've also had family court judges be so happy and give me this order and say, I'm granting you immigration status in the United States. Like, no, that's also not your job. You're a family court judge. Great, super, like, good for you. But you have no power invested to you by nobody to grant immigration status to anybody. So you get both ways, right? The overeager and the it's against my political beliefs crowd. But the idea is no one's granting immigration status by this. It's the benefits agency. It's USCIS that adjudicates this. In the past, I wouldn't say they were rubber stamping, but they were much more generous than they are now. Before, we had adjudication at every local office. Here in New York, we're very lucky. It was mostly lawyers working on these cases who actually, after trainings by us, understood state court law. Now it's centralized, and it's at a bunker underground in Missouri. And apparently, nobody in Missouri understands state court law in New York, let alone anywhere else. So you get requests for evidence. I've gotten this one a couple times. This is a winner. Sending back to me the state court form that the state court judge signed and saying, how do I know that he or she relied on state court law? Gee, I don't know. He made it up, right? Like, it's just completely bonkers. So I get things like that back from immigration. So there's no more rubber stamping, and the judges are aware of that. And so the chief judge, like at their judge meetings, whatever, there's always discussion about SIJ, but you have at the higher levels a total acceptance and buy-in of it. And so sometimes it's really uncomfortable, right? It's taking it to the supervisor and making sure that he or she understands, like, this is actually the law, right? This is what you're required to do. You're not making an immigration finding, you're making a state court finding, just as you would for any other child. Yeah.
And to the argument that it's, you know, sort of a button hook around the immigration system, I feel like that implies that our general immigration system is this smooth, working, logical machine,
yeah,
where there is some sort of pathway for young people. I mean, it just creates, like, SIJ solves an inherent contradiction
yeah,
in the way our legal system conceives of children.
exactly.
Because if you have a foreign national child in foster care, then you have a foreign national minor in locus parentis of a state-run agency.
Yep.
Right, like that is an inherent contradiction.
Yeah.
Right.
And how SIJ was created was to serve the foster kids, right? It came out of California in 1990 when all these foster kids were aging out and then realized they couldn't work in the United States and they couldn't go to school because they had no money, and how are they supposed to afford it? So Congress used to sort of work back then. They passed SIJ, right? It was a good thing that they did in order to respond to the need of kids aging out of foster care who had nothing and nobody, and trying to find a solution for them. Yeah.
For the fourth prong,
Yeah.
if reunification is possible with one parent, is that?
Yep, that's fine as long as we're not in Nebraska. Nebraska interprets one or both to mean both. I don't get it, right? If you practice also in Nebraska, I'm sorry, that's awkward in terms of your Supreme Court's reading. But here, one or both means one or both. And also, sorry, this other similar basis, here in New York, that's interpreted as death of a parent. So if you have a kid with dead dad or dead mom, you have a SIJ case, right? You can't reunify with a dead person. It's just, yeah, that doesn't work.
Sorry, I meant to, if you can reunify with one parent.
Okay, but not the other parent.
Right.
Yeah, fine.
Yeah, one parent SIJ is
That's fine.
totally okay.
Okay, super. Is that it? Yeah, common concerns, Geoff.
All right. So this also is like a great opportunity for assorted other miscellaneous questions that come up. This was just sort of what had been circulated in the emails going back and forth of things that had come up, and so these were like the ones I wanted to flag for sure, but if other things occur as we're talking, please. So TROs and family offense petitions, how to handle those ramifications. So even though it's not a criminal finding, an admission to the underlying facts of a TRO or a family offense petition can definitely be used in deportation proceedings and can make it impossible for someone to, to adjust to legal permanent resident status. So if there's a TRO or a family offense, like, it's definitely a red flag.
Yeah, it means you can't, if you have any kind of order of protection, whether it be from the family court or the criminal court against you, you cannot show good moral character for immigration purposes during the period of time for which that order of protection is valid, meaning that you can't naturalize. Let's say if you're a green card holder, right? You'd have to wait until that order of protection expired.
The divorce, separation, and impact on status aspect, I think it's very case specific because it really depends on like where they are in both processes.
Yeah, exactly, right? So let's say, we got married, right? So Geoff and I got married, right? I'm the U.S. citizen, you're my immigrant husband. Congratulations, there we go. Okay, super. So we got married, we have a new marriage because we just got married now, right? And I'm going to petition for Geoff now because it's my responsibility, right? I've chosen to petition for Geoff.
Just fill out forms and everything.
Right now, right? They're done. So we filed those. When they interview us, there's always going to be an interview, right, for marriage-based questions where they're going to look at all the materials we've submitted. If they believe our good faith marriage here, Geoff will be granted what's called a conditional green card. Why is that? Because we have a new marriage, it's less than 2 years old. Geoff will get this 2-year green card. That means 90 days before the 2 years is up, Geoff and I, meaning I, have to petition to remove the conditions on Geoff's green card. So I still have to show that we're still in our good faith marriage, or if there's been a divorce, or if we're not on good terms anymore, we still have to show that we had this intent to establish a life together. So we have to basically show, in immigration law, in terms of marriage, there was a lot of marriage fraud. There were marriage fraud acts. So the idea of that marriage is you need to show this intent to establish a life together to get over any idea that there might be marriage fraud there. So that would be where the timeline of a separation, something like that, would come up as well. Yes?
Is there any time when if a couple signs a prenup that's looked on negatively?
It's in the next slide. Just real quick. So this was something that came up in some of our discussions that I just wanted to flag as something that's horrible, but very likely to come up, which is retaliation by litigants against domestic workers and other childcare providers. If you have person A and person B who are getting divorced and person B feels like, the babysitter took the side of person A, it's very easy to report someone to ICE. And if you're employing them, you have a lot of information that you could give to them. I just wanted to flag it because it's awful. And I don't have a quick way for that to be solved, but I just imagine that it's something that could be happening quite a bit in the near future. Prenups, yeah. So I've talked to a bunch of different colleagues about this, and the general consensus is just the less said about the immigration, the better.
Ideally, nothing.
Yeah. Even if it's a well-intentioned prospective thing where in the prenup they're saying we affirm that we're not going to do anything to endanger the other person's immigration status. I think we all could imagine this administration looking at that and saying, oh, so it's like a business contract, so this is not a real marriage, that you're right. So just leaving all of the immigration things out. Designations of parental authority. This is another really awful thing. It's a good thing, but it's an awful thing that we have to talk about. So the designation of parental authority is something that OCSF created for people who are in danger of going to jail immediately. It doesn't work as totally as guardianship or stand-in guardianship, but it allows for non-emergency medical treatment and enrolling in school. So I recommend that every person who is not a citizen have a designation of parental authority available, where they list another person who is able to do these, seemingly simple things. But if a child has a chronic medical condition, for example, it doesn't need to get as bad as like a full-blown hospitalization, attack for this person to, just see their doctor regularly.
Yeah, there is a task force with the family court to try to get the standby guardianship law amended to include deportation or threat of deportation as one of the, detention and then deportation as one of the elements in which a standby guardianship would actually kick in. That hasn't happened yet. The law hasn't changed yet, but they're working on it. They're aware of it. So that's something that might come up in the future, which would, be something to be aware of when you're counseling clients.
Oh, and the great thing about DPAs is that they're like a power of attorney. You don't need to go to court for them. Just requires notarized signatures by both parties. And they don't even need to happen in the same place at the same time. So it's a great tool for, say, an undocumented parent with a U.S. citizen child that is very, very worried about what might happen. Yeah. And then impact of ICE presence in court. Technically, courts are supposed to be considered sensitive locations, similar to hospitals and churches and schools. So far, under the Trump administration, they've definitely been pushing the line with schools and with hospitals. I think it was in Virginia at a frostbite unit in January. ICE was literally camped out like right outside and was collecting people as they would come out from frostbite treatment. And they're definitely around in courts and in the immediate areas surrounding courts. So
my advice would be to, walk your client to the subway, right? Walk your client out of court if it's at all possible, or have someone else from your office who can. And how are they deciding who is an immigrant? By racial profiling, right? And it's horrible, and you see it all the time. You see this in Brooklyn every day. So it's not something that's just happening on Long Island or just happening in other states, right? It's happening here. All right.
That was it.
So now you know everything about immigration law.
You're
That's
set. You're
super.
ready.
Yeah, you're ready. We're happy to hang out if you have any more questions, but thank you so much for your excellent questions throughout the presentation, and thanks for coming. Yay.